Good morning, ladies and gentlemen. This is Bexar County Court at Law number 6 in the Bexar County Veterans Treatment Court. This is our motion to revoke probation docket. It is Wednesday, the 27th of October, 2021 at approximately 10:25 a.m. Representing the state in all matters will be Assistant Criminal District Attorney Megan Galloway and Eddie Villarreal. Representing the Bexar County CSCD in all matters will be Ms. Susan Gross, who I will swear at this time. Ms. Gross, if you'll please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
The cases set for hearing today are 656-814, State of Texas versus Nicholas Rios, represented by Mr. George Manning. Cause 649-194, State of Texas versus Kimberly Martin, represented by Mr. Guillermo Lara. Cause number 653-775, State of Texas versus Richard Escobedo, represented by Mr. Michael Bellevue. Cause number 636-502 and 672-113, State of Texas versus Mark Clark, represented by Ms. Valerie Headland. Cause number 635-510, State of Texas versus Joe Diaz, represented by Mr. Ross Brendel. Cause number 629-957, State of Texas versus Michael Riviezo, represented by Mr. Jonathan Ross. Cause number 648-747, State of Texas versus Lorraine Valenzuela, represented by Ms. Karen Corby. Cause number 575363, State of Texas versus Alec Arguello, represented by Mr. Keith Engelke. Cause number 634471, State of Texas versus Jacob Juarez, represented by Ms. Zally Gonzalez. Cause number 634471, State of Texas versus Stephanie Torres, represented by Mr. Shannon Locke. Cause number 660512, State of Texas versus Jacob Jurgens, represented by Mr. Eduardo Garcia. And cause 619095, State of Texas versus Monica Aguilar, represented by Mr. Ross Brendel. Pat, do you want to start with inmate cases or does it matter?
It's up to you, Your Honor.
Is Mr. Manning ready to go forward on Mr. Rios at this time?
Yes, I am, Your Honor.
All right, let's do that one. This is cause number 656-814, State of Texas versus Nicholas Rios. And this is a first amended motion to revoke community supervision. Mr. Rios and Mr. Manning, I have two documents I need you to identify your signatures on for me. The first is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. Mr. Rios, is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Manning, is this also your signature on this document, sir?
Yes, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Mr. Rios?
Yes, sir.
And Mr. Manning, as attorney for Mr. Rios, is this also your signature on this document?
Yes, it is, Your Honor.
Thank you. Mr. Manning, my understanding is that this is an uncontested first amended motion to revoke community supervision. Is that correct?
Correct, Your Honor.
Mr. Rios, and cause 656-814 on the first amended motion to revoke community supervision. How do you plead, sir?
It's either true or not.
Oh, true. Oh, true.
All right. Court accepts the plea of true with an explanation if y'all would like to give one. Ms. Gross, would you please advise the court and the parties of the status of Mr. Rios' probation?
Yes, Your Honor. Mr. Rios has been reporting as directed. We last saw him October 25th of 2021. He is paid $258 towards his balance of $14,423.94, and he is currently delinquent $1,354. We have no record of any of his 48 hours community service having been completed. He has one negative drug test. He has one positive drug test for alcohol, and he failed to submit to drug testing on one occasion. We have no proof of enrollment or completion of the DWI Education Victim Impact Panel or the CATSNP programs. He's currently testing on Smart Start Mobile at 6 times per day, and he has had 11 skips. and 0 high bracs. He has no criminal history. This is his second violation report, first MTR. This is a reform judgment that occurred on 9/15/21. His officer is recommending that his probation be extended for a period of 3 months and that he go to SATA for 120 days with aftercare and then reinstall his Smart Start device upon release of aftercare or of SATA. I'm sorry.
Was there not a prior motion to revoke probation that was heard on 9/15/21 that took away Mr. Rios' deferred adjudication? Is that true or not?
Yes, I did mention that.
Okay, so there's one prior MTR on September 15, 21. Okay. Mr. Manning, what are you requesting?
Your Honor, frankly, because of SATA being waitlisted at this time, my client does request that he could just be revoked. A term suggested by the state was 90 days if he were to be revoked. I've had other clients stuck waiting 4 to 6 months for SATA because of COVID holds, quarantines, and the lack of beds and available treatment positions. So given that and my client's financial resources, I believe it would be more productive for him to simply be revoked and do an additional 90 days if you would do so, Your Honor.
Ms. Gross, did I hear you correctly that the amount of money that Mr. Rios still owes the probation department is $1,354? Is that correct?
No, sir. That is what he is delinquent. His balance is $14,423.94.
Not 14,000.
Yes, $14,423.94.
That includes restitution, I guess.
Yes.
Mr. Manning, have any actions been taken to address restitution on this case?
No, Your Honor. My client recently got a job as a mechanic, and before he was in Barrett County Jail, he had recently gotten that job. He does not know whether that will be waiting for him when he gets out.
Okay, Ms. Gross, what was the original fine amount on this particular case, please?
$750, Your Honor.
Mr. Rios, in cause 656-814, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your probation. I assess 6 months in the Barrett County Jail, a $750 fine plus court costs, credit for time served, time and money to run concurrent.
Sure.
And go ahead.
Judge, for the record, you didn't ask me for my recommendation.
Oh,
so
I
if may
apologize.
just add, the
State, I would love to hear your recommendation. I apologize.
the state's recommendation is to revoke the defendant and that he spend 90 days in the Barrett County Jail.
Okay. And Mr. Manning, if your client is interested in paying all or part of this restitution amount while he is in jail, the court would probably favorably consider that as a mitigation, and the possibility exists that his remainder of his jail sentence could be waived if that restitution were paid. Now, I understand that's a lot of money, but I wouldn't want involved. So it's the best I can do under the circumstances.
I understand, Your Honor.
Anything further from the state or the defense on Mr. Rios?
No, Your Honor.
Nothing further from the defense, Your Honor.
Good luck, Mr. Rios. Thank you, Mr. Manning.
Thank you.
Thank you, Your Honor.
Let's see.
Can I be excused, Your Honor?
You bet, absolutely.
Thank you.
Are we
Judge.
ready on, nope, I don't have a cover sheet on this Martin.
No, they're in the breakout room right now, Your Honor.
Are we ready on Richard Escobedo with Mr. Bellevue?
Yes, Your Honor.
Yes.
Okay. This is cause 653-775, State of Texas versus Richard Escobedo. This is a motion to revoke community supervision. Mr. Escobedo and Mr. Bellevue, I have two documents I need you to identify your signatures on. The first is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Mr. Escobedo, is this your signature on this document, sir?
He may not know
Mr.
how to.
Escobedo, you are muted. You can hold down the space bar when you talk.
Richard, hold the space bar down when you talk.
Unmute. Okay.
Okay, I think we got you, Mr. Escobedo. Can you hear me, sir?
Yes, I can, sir.
All right. Mr. Escobedo, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that supposedly has your signature on it. Is this your signature, sir?
Yes, it is, sir.
Thank you. And sir, I'm going to ask you to turn your microphone off when we're not specifically talking to each other because there's background noise from the jail. Thank you. Mr. Bellevue, as attorney for Mr. Escobedo, is this your signature on this document also?
Yes, it is.
Thank you.
Yeah. I don't. Yeah, I mean, I told.
Mr. Escobedo, you
Yes.
need to turn your microphone off unless I ask you a question, okay?
He
I
doesn't
don't
know
know how to turn it off. Wait up. I think the mic is being off.
I guess that's the choice. I pretty much didn't think I was going to get charged. I just knew that. I mean, like my PO told me, she said as soon as she finished.
I don't know nothing about you, man.
All right, make sure you know how to turn it. Make sure you know how to turn it back on, Mr. Escobedo. Do you know how to turn it on and off? Ask the officer right now if you don't know how to do it for him to teach you. Now you're off. Can you turn it on? Can you turn on your mic, sir? Mr. Escobedo, if you can hear me, turn on your microphone, please.
Yes, I can, sir.
There you go.
Good.
Now,
There you go. Perfect.
you know how to turn it on and off now, Mr. Escobedo?
Yes, I do, sir.
All right, great. At this time, I'm looking at a document entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document, Mr. Escobedo?
Yes, it is, sir.
Thank you, sir. And Mr. Bellevue, is this also your signature on this document as attorney for Mr. Escobedo?
Yes, it is, Your Honor.
Mr. Bellevue, my understanding is that this is an uncontested motion to revoke community supervision. Is that correct?
That is correct.
Mr. Escobedo, on clause 653775 on the motion to revoke community supervision, how do you plead, sir?
Yes. Yes, sir.
It would be true with an explanation.
Court accepts the plea of true with an explanation. Ms. Gross, would you please advise the court and the parties of the status of Mr. Escobedo's probation? I remind you, you're still under oath.
Yes, Your Honor. Mr. Escobedo has performed very poorly on probation in that he attended intake and signed his conditions on February the 4th of 2021, and we've never seen or heard from him again. He has not made any payments on his fees. He has a balance of $850 and is delinquent $612. We have no drug tests on file because he never reported. We have no proof of him completing any of his 36 hours of community service, nor do we have any proof of his enrolling in or completing a stress class. His arrest history includes burglary with intent of theft, which was a felony, criminal mischief 20 to 200, driving while license suspended, driving while intoxicated open container, possession of marijuana 0 to 2 ounces, DWI second, DWI third, which was a felony and he was sentenced, evading arrest, detention, aggravated assault with a deadly weapon, which remains as a night mag, assault bodily injury married, theft 100 to 750, and this instant offense. This is his first violation report, first MTR. And his officer is recommending that he be enrolled in the stress class within 5 days of release, and that he provide proof of employment within 5 days as well.
Mr. Bellevue, what are you requesting, sir?
Sorry about that, Judge. My computer died.
Okay, can you hear me now?
I can.
What is the defense request for Mr. Escobedo?
We're asking that he be continued on probation, Your Honor. He was homeless at the time. He does not have a phone. He is now living at Haven for Hope. He is also working at Haven for Hope. He can pay his fees. Now that he's allowed to report in person, he can, as he said, he can walk across the tracks and just report when he needs to report. And he's the one, he went and turned himself in. He did not have to get tracked down, and he would like to continue his probation to show the court that he can complete this.
And state recommendation, please.
Your Honor, the state would recommend that the defendant be continued, that he report weekly in person for 30 days. And if he's able to do that, then we would move him back to monthly and substantial compliance within 30 days, which would include enrolling in his classes and starting on his community service.
And Ms. Gross, what was the fine amount on this case, if you know?
Judge, he was never assessed a fine on this case.
So it's a $0 fine, is that correct?
Yes, sir.
And does everybody agree that it's a Class B offense?
Yes.
Yes, Your Honor.
Mr. Escobedo, and cause 6775, the court accepts your plea true with an explanation. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail, assess a $0 fine plus court costs, credit for time served, time and money to run concurrent. My records reflect he has at least 33 days credit that he should receive. Anything further from the state or the defense of Mr. Escobedo?
No, Your Honor.
Nothing from the state.
Good luck, Mr. Escobedo. Thank you, Mr. Bellevue.
Thank you, Judge.
Okay. We ready on Mr. Diaz? Mr. Brendel? Ross, are you with us?
Yes, Your Honor, I'm here.
Are we ready to go forward on Mr. Diaz case?
We should be.
Okay, this is cause number 6355510, State of Texas versus Joe Diaz. This is a motion to revoke community supervision. My understanding is this is an uncontested motion. Is that correct, Mr. Brendel?
Yeah, I guess it's uncontested. We picked not true just because we weren't completely sure the allegations regarding it. But at this point, we're just asking that he's released on time served for being held in the Bexar County Jail for almost 2.5 months pending the SATA program, which originally he was told it would take a couple of weeks. So we're asking that time that he's served in there be counted as his sentence and him be released.
All right, let me clarify for the record in the state what my understanding of this case is. Mr. Diaz had a previous motion to revoke probation. And Susan, do you have a date on that one?
It was on,
October 20, no, that's today. Yesterday.
hang on, I'll get it for you, Judge.
It was about 2 months ago, is my recollection. Would that be accurate, Mr. Brendel?
Yeah, it was around 2 months ago, and then of course he was held in there prior to that pending the MTR hearing.
Judge, I have the date of that hearing. That hearing was on August 19th of 2021.
Okay. My recollection is, and correct me if I'm wrong, Mr. Brendel, that Mr. Diaz at that time was offered an opportunity to either be revoked and do a jail sentence or to volunteer to attend the substance abuse treatment facility. Our understanding from what was told to us by the folks at the substance abuse treatment facility was he would be in jail somewhere between 30 and 60 days before a SATF opening would occur. And if you were admitted into substance abuse treatment facility, he would spend 120 days there, and if successful, come out and be back on probation. Is that your recollection basically of where we were at the last hearing, Mr. Brendo?
No, I didn't remember them saying 60 days. It was we were under the impression that it would be just a couple of weeks before he got into the SATF program. Had we known it would have been several months, we obviously probably wouldn't have elected that one. But because he's been waiting there so long, and he had a tooth abscess where he had fever and everything, and due to all his the health concerns and everything, we're just asking that he's released on time served.
Okay. You agree that Mr. Diaz at that time had volunteered to go to the substance abuse treatment facility. Is that true?
I agree that he did do that.
All right. The point I'm trying to make is I agree with the defense, and I think the state fully agrees with the defense that no one knew specifically how long Mr. Diaz was going to be held in jail before an opening at SATF occurred. And then Mr. Diaz had this dental problem, which caused further delay. Anyway, I agree with the defense wholeheartedly that Mr. Diaz has spent way too much time in jail. So that being said, my understanding is I had a discussion with Mr. Brendel. I'm not sure if you filed an actual motion or you just sent me an email that requested basically pointed out exactly what you stated today, that Mr. Diaz had spent far more time in the Bexar County Jail waiting to get into SATF than anyone had anticipated. Is that true, Mr. Brendel?
Yes, and I sent multiple emails to different people, and I filed a motion.
And I checked with my staff attorney who advised me I had lost jurisdiction over that original MTR because it was past 30 days. And I related to you that my staff attorney had indicated the only clean way to do this legally that she was aware of would be for us to file another motion to revoke probation if Mr. Diaz were to refuse to go to the substance abuse treatment facility, because that's the only real allegation that the probation department would have. Is that correct, Mr. Brendo?
Yes, Your Honor. And that was, you're right, there is a kind of procedural deal there where that seemed to be the only option because he was technically on probation, and that would effectively, enable him to get out on time served.
All right. Well, here's my dilemma. You just told me that the defendant now wants to plead not true to refusing to go to the substance abuse treatment facility. They've got a bed for him right now, is my understanding. If he wants to plead not true and still go to the substance abuse treatment facility, my understanding is we can do that. Is that what he wants to do?
We picked not true because we weren't aware of the actual allegation at this point, but he will elect true if that enables him to get released on time served.
All right. Let me make clear for the record. Nobody's mad at Mr. Diaz. Mr. Diaz has been a good scout. He volunteered to go to SATF. Very few people do that. I agree with the defense wholeheartedly that it has taken the probation department much, much longer, and we certainly did not know about a dental problem that was going to cause additional delay. So my understanding is if Mr. Diaz is willing to plead true to the fact that he is now, under the circumstances, refusing to participate in the SATF program, even though I have the authority to send him there, whether he wants to go or not, I think that's ridiculous. There's no reason for someone to be there and not pay attention and not learn what they're trying to teach them. So if the defense is willing to plead not true and explain it, which you've already done, true to this allegation and explain it, which you've already done, I find great mitigation in that and we can proceed. Is that what the defense would like to do?
Yes.
All right. Court accepts the plea of true with an explanation in cause 6355110, State of Texas versus Joe Christian Diaz on his motion to revoke community supervision. Ms. Gross, would you please advise the court and the parties of the current status of Mr. Diaz's probation?
Yes, Your Honor. As discussed, we were here on this motion to revoke the original one on August 19th of 2021, at which time he elected to voluntarily go to SATF. His reporting has been good. He has been in jail since that time. He's paid $160 towards his fees. He has a balance of $1,150 and is delinquent $367. There's no record of any of his 24 hours community service having been done. He does have 2 positive drug tests for alcohol and benzodiazepine since being placed on probation. And we have no record of his enrolling in or completing DWI education, victim impact panel, or CAPSNP. And we are here today because he is refusing to go to SATF. This is his second violation report, second MTR, and his officer is recommending that he still go to SATF, followed by aftercare. His criminal history is he has a prior arrest for assault, bodily injury, family, a felony assault on a police officer, judge, and possession of a controlled substance, penalty group 3, less than 28 grams.
State recommendation.
Your Honor, the state is recommending revocation and a judgment satisfied.
Mr. Diaz, in cause 6355510, the court accepts the plea of true with an explanation on your motion to revoke community supervision. I grant the state's motion to revoke community supervision. I sentence you to 6 months in the Bexar County Jail. Susan, what was the original fine amount on this one?
Judge, it was $500.
$500 plus court cost, credit for time served, time and money to run concurrent, judgment satisfied. Anything further from the state or the defense on Mr. Diaz?
Nothing from the state.
Is that all okay with you, Mr. Brendel?
Yes, and just to clarify to him, that means he would be released here pretty soon.
I don't run the jail, but normally I think it's going to take them 24 hours once they get word. It's going to be later on this afternoon before this gets on the computer. So my guess is it's going to be tomorrow morning before he's actually released, but I'm just guessing. Okay. You're welcome to call the jail and talk to them and see what they tell you.
All right, thanks, Judge. I
All
just wanted to clarify to him because sometimes, it sounds like when they hear that, they don't know that they're actually being released, but he will be released in the next couple of days.
That's my understanding. If he's not released by noon tomorrow, feel free to text me and I'll give a call over there and find out what's going on if you want.
Great. I appreciate it, Judge. Thank you
All
so
right.
much.
Good luck, Mr. Diaz. Thank you, Mr. Brendel. Let's see. Mr. Brendel, you want to go forward on your next case at this time while you're still with us?
Yes, Your Honor, that would be awesome.
All right. This is cause number 619095, State of Texas versus Monica H. Aguilar. And this is a motion to revoke community supervision. Ms. Aguilar, I have 2 documents for you to identify your signature on for me. The first is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. Is this your signature on this document, ma'am?
Yes, Your Honor, it is.
Thank you. And Mr. Brendel, as attorney for Ms. Aguilar, is this also your signature on this document?
Yes, Your Honor.
And next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Ms. Aguilar?
Yes, sir, Your Honor.
Thank you. And Mr. Brendel, as attorney for Ms. Aguilar, is this also your signature on this document?
Yes, Your Honor.
And Mr. Brendel, my understanding is that this is an uncontested motion to revoke community supervision. Is that correct?
It's contested in the fact that some of the allegations that were stated, we do have explanations for those about, them being not exactly true. So in that way, it would be contested on some of those allegations.
The defense has 2 options. They can ask for what I call a full-blown contested motion to revoke community supervision. And normally the only additional witness called is going to be the actual probation officer for the defendant. Or you can consent to my jurisdiction and still plead not true to certain conditions, i.e. true with an explanation or not true with an explanation, and allow me to make a decision on whether they're true or not.
And Judge, just for the record, that
Yeah.
officer is unavailable. She is on maternity leave, so it would be probably 6 to 8 weeks before we would be able to hear the motion.
All right, Mr. Brendel, what would y'all like to do on that one?
With that being said, since we would be contesting several of the allegations, I've conferred with the state, and due to the fact that she has been doing drug testing, but it was through a facility next to her house because she can't drive, and she works at home, and she did submit actually proof of registration to her the class 2 her probation officer, which I provided to Ms. Galloway. We were seeing if we could just, close her case as time served for the time that she spent awaiting on the first MTR.
I'm just now going over the allegations in this particular motion to revoke community supervision 619095. And their allegations, there's a positive marijuana test, your analysis, I guess. There's 1, 2, 3 failure to submit to drug testings, which might play into what you're saying. She didn't have transportation or whatever her reason is. And that she didn't attend a DOEP course. And those are the only allegations.
Yeah, and then we submitted proof that she registered for the course. And also another reason for the drug testing was that she had come in contact with someone with COVID, and she was told not to come into the drug testing. So she was a bit confused as to when she would return, but she did drug testing at a facility next to her house that she could get to. So, based on the fact that the probation officer wouldn't be available for sounds like a couple of months. I know that a recommendation had originally been that she attend the SATIV program, but due to the fact that she's not, there's no allegations, she's not addicted to alcohol or any hard drugs or anything. From what the tests show, I think that would be a lot of money probably ended up being wasted on her. She's employed and she's a very productive person. But it just seems like with the probation officer not being able to testify as to the allegations, I'm thinking the best thing to do with the recommendation of the state is just to give her time served, the several weeks she's spent for her first MTR, and just close the case.
Well, I can understand from the defense where that would be a wonderful idea. However, we're not really in that position to make plea bargains on motions to revoke probation. If the defense at this time is willing to enter a plea of truth and explanation to any of these conditions, we can go forward. If you want to plead not true to all the allegations and request a fully contested motion to revoke community supervision, I will check with my staff attorney. I don't know that the actual probation officer needs to be present at that if she's obviously away on medical matters. And we can go forward at a much sooner time than projected. Obviously, under the circumstances, there's allegations of a positive urinalysis test for marijuana, and failure to submit to drug testing 3 times is probably going to consist of a probation officer reading off of a log that was provided by the lab that said this person didn't show up or showed up and didn't give a sample, whatever happened. And that's the only allegations that I see on this document. 3 failure to submit, and didn't finish the theft program level 1 program. And obviously, if the defense has some sort of graduation certificate for that, you can rebut that one. Otherwise, it's just going to be in the records of the defendant. So that's what we're dealing with. There's nothing really.
And Judge, also the drug offender education program is alleged.
And Your Honor, if I may, Mr.
Sure.
Brendel did provide me with proof of enrollment in the DOEP class that was provided to him by the defendant.
Okay, state you want to move to waive condition 18, which is the allegation of the DOEP course now that we know that it has been complied with.
Yes, Your Honor.
All right, any objection from the defense?
No objection, but I would like to see what their recommendation would be, considering that a fully contested hearing would be would probably not happen due to the probation officer, or what would happen in that sort, situation?
I'm sorry, what would happen if what again? I apologize, I missed the question.
Well, I guess what I'm asking is if we do a fully contested hearing, would she just be told to go to the jail and wait for that?
No, I mean, she's on bond right now. Is that not correct? Or is she still in jail?
She's not on bond. They issued the warrant several days ago, and actually she called me really worried about it, and I could not find her case in the system.
You're under, she has an active warrant at this time because of the MTR. And you can't pull the warrant because it would.
Negate the MTR.
Exactly.
She would still remain with a warrant on her, is what it will.
Yes, Your Honor.
Yes.
With that being said, I think that would probably, some might happen where she ends up going to jail there. What would be the after conferring with the state? I know the initial recommendation was to attend the SATIV program, which, it would take forever to get in there, and she probably end up spending a long time in jail. What if we were to, if an alternative would that be suggested, wouldn't outpatient treatment, I think, would probably be more appropriate for her situation, since her initial arrest had nothing to do with alcohol or drugs. She's shown that, through a drug test that she's done through a lab, that she was false for everything. There's no indication that she's addicted to alcohol or any kind of hard drugs. And
Mr. Brendel, I apologize. Let me interrupt. We're not at that point yet. If you would like, I'll put you back on the back burner for a minute and get to the other folks who are waiting and do their MTRs, and we can come back to yours, and I'll give you another chance to confer with the state again. It kind of sounds like that's what you would like to do. Is that correct?
Yes, Your Honor, considering that there's some, things going on that, with the program.
Thank you.
I appreciate it. Thank you.
No problem. All right, Ms. Corby, you ready to go forward on Ms. Valenzuela?
Yes, Your Honor.
Okay, this is called 648-747, State of Texas versus Lorraine Valenzuela. And this is a motion to enter adjudication of guilt and revoke community supervision. And Ms. Valenzuela and Ms. Corby, I have two documents I need you to identify your signatures on. The first is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Ms. Valenzuela, is this your signature on this document, ma'am? And Ms. Valenzuela got her microphone on.
Yes, sir.
Okay, thank you. And Ms. Corby, as attorney for Ms. Valenzuela, is this your signature on this document?
Yes, Your Honor.
The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Is this your signature on this document, Ms. Valenzuela?
Yes, sir.
And is this your signature also, Ms. Corby, as attorney for Ms. Valenzuela?
Yes, Your Honor.
This is a motion to enter adjudication of guilt and revoke community supervision. Ms. Corby, my understanding is this is uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, Your Honor.
Okay, Ms. Valenzuela, in clause 648-747 on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, ma'am?
True.
And thank you. Court accepts the plea of true with an explanation. Ms. Gross, would you please advise the court and the parties of the status of Ms. Valenzuela's probation? I remind you, you're still under oath.
Yes, Your Honor. Ms. Valenzuela has been reporting as directed. We last saw her on September 28th of 2021. She has paid $40 towards her fees, has a balance of $837, and she is currently delinquent $225. She has completed 16 hours of her 48 hours of community service. She has had 3 positive drug tests, 2 for marijuana, 1 for alcohol, and she failed to submit on 1 occasion. And we have no proof of enrollment or completion of the theft class. She has no criminal history. This is her first violation report, first motion to revoke. And her officer is recommending that she provide weekly UAs for a minimum of 8 weeks, that she be going to the CATS IOP program, and that she show substantial compliance within 30 days.
And Ms. Corby, what are you requesting?
Judge, I'm sorry, I thought that she had finished the theft class, Ms. Gross. I thought that was something that you had put in your court summary, that she had successfully completed the theft class. As a matter of fact, it was completed August 13 of 2021. I just wanted to clarify that before we got started.
You can ask Ms. Valenzuela if she's attended it. I
You're
don't apparently,
mute, Susan.
Ms. Gross does not have proof of that. Would that be accurate, Ms. Gross?
You're muted. Unmute.
Correct, Your Honor. I was looking something up. I'm sorry.
No problem. Ms. Corby thinks that Ms. Valenzuela did attend the ATSE anti-theft class, and I'm wondering if the state, i.e. the probation department, has proof of that, and maybe she went and has not turned it in yet. I don't know.
I am looking it up, Your Honor.
Judge, I'm just looking at the report that I was provided from probation, and it does say very clearly, the defendant has completed theft program level 1 in 8/13/21. So my argument is this, Your Honor, my client's been on probation a little over 3 months. She has been substantially complying. My understanding is she has completed the theft class per the report I received from probation. She's completed 16 hours of community service. This is her first motion to enter adjudication of guilt. She has no prior criminal history. With reference to the employment, she has recently acquired a food truck. She's going to be meeting with the people that provide the permits within the next week. And so she's trying to employ herself through selling taquitos and whatnot in a food truck. We're asking that you consider allowing her to maintain her deferred adjudication status, Your Honor. Again, she has no prior record. She's 33 years old. A theft conviction is going to really set her back for the rest of her life. I'd like you to consider the fact that she has substantially complied. I do think the state's recommending a DOEP class, which she's more than willing to do, and weekly UAs, which she's more than willing to do. I think there were a few little problems with her UAs. I don't want the court to have the false impression that she tried not to give UAs. There were a couple of times she went in to give UAs, and when the sample got to the UA lab, the lids weren't screwed on properly, so they leaked out. That wasn't her fault. My understanding is she does not put the lid back on the UA after she provides the UA. So I would just say, Judge, she has been trying, and we're asking you to allow her to maintain her deferred status and to not revoke her.
Judge, if I may, that UA is not counted against her in this proceeding. We understand that things do happen with the lab, and we do not hold those against the defendant. And as a matter of fact, they are not even recorded in the motion to revoke.
Judge, dirty alcohol is not recorded in the motion to revoke either.
As
Wait, everybody stop talking. I'm sorry, Ms. Corby, say again about alcohol.
I think that the probation officer has stated that she was positive for alcohol, but that's not on the MTEAG either, Your Honor.
That's correct. The judge asked for a historical compilation of violations. And Judge, I did find buried in the officer's notes that the defendant did indeed complete the theft class. So that was in my error. I do apologize to the court.
All right, I got a question for Ms. Gross. I've never seen this before. There are currently 2 invalid urinalysis tests that were no fault of the defendant because the quote lid was crooked, unquote. What does that mean?
That means that the lab technician did not screw the lid on correctly and it leaked out, and there was nothing left for the lab to test by the time it arrived in Arizona.
Again, Your Honor, just further proof that my client is trying. She is trying to comply. And every time she goes to give UAs, I think she has to pay. So, I mean, I think she really is trying, Your Honor.
I got it. State recommendation, please.
Your Honor, the state is recommending that this defendant be continued on deferred adjudication, that she be placed on weekly UAs until she provides 30 days of clean UAs, that she take the DOEP class and that she shows substantial compliance within 30 days.
Hey, Ms. Valenzuela, I have one question for you, ma'am. Are you going to stop smoking marijuana?
Yes, sir.
Excellent answer. Ms. Valenzuela, on clause 648-747, the court accepts your plea of true with an explanation. I deny the state's motion to revoke your deferred adjudication probation or to continue on deferred adjudication probation with all prior requirements and no sanction at this time. Although I have the authority to put you in jail for 30 days to get your attention, will that be necessary?
No, sir.
Oh, another good answer. Altering and amending conditions, adding the DOEP course and weekly urinalysis test. Ms. Corby, once she shows me 4 clean, continuous weekly urinalysis tests, I'll put her back on monthly urinalysis tests, but you'll have to let me know that she's done that because I won't know. Fair enough?
Thank you. Yes,
All
appreciate
right.
it.
Good luck, Ms. Valenzuela. Thank you, Ms. Corby.
Thank you,
Your
Mayor
Honor.
Bates.
All right, Ms. Valenzuela, you will be receiving an email from me before the end of the day with your alternate amended conditions. You need to sign those and return those back to me, okay?
Yes, ma'am.
All right, if you have any questions, give your officer a call and keep in touch with her in regards to your next appointment.
I will, ma'am. Thank you.
All right, good luck to you.
All right, we're going to take a 2-minute break while I get the paperwork together for our last 2 jail cases, and we'll get y'all out of here.
Thank you. Bye.
Megan, can you go in a breakout room for just a minute with Miss Gonzalez while he's taking a little break?
Sure.
Thank you. Okay, let me find y'all so I can put you in there. Okay, Miss Gonzalez, if you can go into room 8, and Megan, if you can go back into 8, let me know.
Thank you.
Uh-huh.
You're okay, Mark. We're just on a break. Well, do you need to go to the bathroom or anything? You're on mute, love.
I want to know if I can talk to you again, ma'am, please.
Oh, okay,
I'll
Pat.
put you in a breakout room.
Thank you.
You should be able to go back into
Okay.
9.
So down at the bottom, Mark, is a little, it's got 4 boxes together and it says join breakout room, and it should allow you to go back into the one we were
To
in.
9.
Yeah, thank
Okay.
you.
Thank you.
Pat, if Judge is still on break, would you please put me in a breakout room with Mr. Brindell?
Could I also go into a breakout room with some point with the prosecutor?
Okay. I'll put you in. Mr. Burdell, go back to room 6, please.
So we need to correct the driver's license number, because that driver's license belongs to local colleague, right? Yes. So he wants to.
Pat, I'm not sure. Mr. Brindell, are you there? You may have stepped away.
Yeah, I'm here.
Okay, can you go to the breakout room with me, please?
Yes, ma'am.
Mr. Brindell, I think I told you to go back into room 6.
Okay, Pat, are you with me?
Yes, Your Honor. And Megan is in a breakout room with Mr. Brindell. Let me get her back. Okay, Your Honor, she should be coming back in.
All right, thanks.
All right, she's in.
Okay, let's go back on the record. Once again, this is Bear County Court Law number 6 in the Bear County Veterans Treatment Court. We're in the middle of our motion to revoke probation docket. Today is the 27th of October, 2021, and it is currently about 11:20 a.m. Mr. Brindell, are you still with us?
Yes.
Judge, we're not done conferring on that.
I know,
So if you
I
could
know.
just,
Everybody just stop talking for a minute. I checked with our staff attorney. She says we don't need to call the original probation officer, that the supervisor can testify about that. So if you want an uncontested hearing, you can still have it today. And then y'all can confer when we're finished doing the rest of this stuff, okay?
thank you.
All right.
Okay. Well, we'll proceed with the uncontested hearing, and just with my recommendation, if
That'll be fine. All right, are we ready on let's see, where's my list? Aha. Ready on Mr. Clark, Ms. Headland.
Good morning, Your Honor.
Okay, this is cause number 636-502, State of Texas versus Mark Clark. And This is a second amended motion to revoke community supervision. I have two documents for Mr. Clark and Ms. Headland to identify their signatures on for me. The first one is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. And in fact, Mr. Clark, is this your signature on this document, sir?
Sir, yes, sir.
Thank you. Ms. Headland, as attorney for Mr. Clark, is this also your signature on this document?
It is, sir.
Thank you.
Yeah, I can hear.
This is a second amended motion to revoke community supervision. My understanding is that this is an uncontested second amended motion to revoke community supervision. Is that correct, Ms. Headland?
It is, but it is his first.
And Mr.
MTR.
Clark, I apologize. Would you turn your microphone off when you're not talking to me, and that way we won't get your background noise? Thank you, sir. Does Mr. Clark have two cases, and what's the status of the second case before we get into this?
So, Your Honor, he has a brand new number one, but it is not listed on the MTR, even though it was filed before the amended MTR was signed. I don't have an offer from the state on that one, but we'd be happy to address that new charge as well when we give our explanation.
Okay, and the second case is a failure to stop and give information, and it's not associated with the initial case. Is that true?
Correct.
Okay,
Yes, Your Honor. There's no file, Your Honor, at this point.
I got you. All right, so basically, we're just not going to do anything on the new case today. It's not alleged on the second amended motion to revoke community supervision, I'm guessing?
No.
Okay, all good. Okay, Mr. Clark, in clause 636502 on the second amended motion to revoke community supervision, how do you plead, sir?
Your Honor, I'd like to speak for Mr. Clark on this, at least, and he can confirm. He'd like to plead true with explanation.
Fair enough. Ms. Gross, would you please advise the court and the parties of the status of Mr. Clark's probation in clause 636502? I remind you, you're still under oath.
Yes, Your Honor. His reporting has been good. We last saw him on September 30th, 2021. As the attorney did mention, he does have a new offense of failure to stop and give info, which is pending. This offense did just occur on October 19th, which is why it does not appear on the motion to revoke. He has paid $733 towards his fees. He has a balance of $330 and he is delinquent $305. He has not completed any of his 36 hours of community service. We do have completion certificates for DWI education and victim impact panel. However, we have no proof of enrollment or completion in the CAPSNP program. His case does expire on November 11th, 2021. This is his first violation report, first MTR. He is currently on Smart Start Mobile testing 4 times per day. He had 103 skips, 3 high bracks of 0.026, 0.156, 0.026. He has been in lockout on the device since January 26th of 2021, and his device was written off on June 30th of 2021. He does have the 3 positives for alcohol, 1 positive via drug testing, and the officer notates that he had checked himself into a VA residential drug and alcohol treatment program. And they are recommending that he be continued on probation, his probation be extended for 1 year, he be placed on a SCRAM device, and that he be given credit for CAPSNP for his enrollment and completion if he can provide a certificate for the VA inpatient residential treatment. His prior arrests include unlawful carrying of a weapon and this new offense of failing to stop and give info.
Okay, Ms. Headland, what are you requesting?
So, Your Honor, if you would indulge me for 3 minutes to give a little bit of background for Mr. Clark. Sure. Mr. Clark served in the Army, Your Honor, and he was over in Iraq In 2007, Your Honor, he watched his battle buddy be burned to death in a Humvee that the diesel fuel and the fuel tank had been placed on the outside of the Humvee instead of inside like normal, because I believe the Navy was involved with that. But Mr. Clark was then brought home. His father was also terminally ill at the time. So he returned to the United States, I think in December of 2009, and he was honorably discharged in January of 2010. He is 100% disabled, Your Honor. He also has 70% PTSD diagnosis with alcohol. There's a more scientific medical term for his alcohol dependency. He has been on numerous antidepressants, and without going into too much detail on his medical situation, he was placed on a very strong antidepressant recently. And I have personal knowledge that that specific antidepressant, whenever you stop taking it, it causes extreme withdrawals and physical and psychological pain. He was booked into Bexar County Jail over a week ago, and he has not had access to those medications because they said they can't get his VA records. So he is really having a very difficult time. He, after the last missed and high BRACs, the skip test, the high BRACs, which according to the court summary that I have, Your Honor, shows that all of those tests were the end of 2020 and the beginning of 2021. Mr. Clark fully takes responsibility for the fact that he did have missed tests. He doesn't make excuses for that. He checked himself into the Sam Rayburn VA Veterans Memorial Hospital, and he has been inpatient, Your Honor, since April. There's 3 phases to the rehab facility. So phase 1 is the early phase, that's 1 month. He was released. He needed to do the late phase, which is 2 months, and then do the PTSD phase, which is 4 months. It's a 7-month total program. And in between phases, Your Honor, is when he picked up the new charge. The new charge was, for a brief explanation, his auntie, who he gives rides to her doctor's appointments. She is in her 70s. She had a stroke. He was picking her up from cataract surgery. He was involved in an accident 2 blocks from his auntie's house. And because of her just coming out of cataract surgery, she wanted to go back home. She was demanding to go back home. He took her home and then returned back to the scene of the accident. So he was not trying to avoid responsibility for the accident. He left, took his auntie home, and then came back. And that's when he was arrested for the warrant on the MTR and failure to give information. He has completed, I believe, 30 some odd classes of AA while in the Veterans Hospital. He has completed the victim impact while in the program, the DWI education while he's in the program. His probation officer, Rebecca Calvillo, has all of his certificates. And I would request, I believe the state is recommending revocation, but this is his first actual MTR hearing. And I know that probation, as Ms. Gross just stated, would like to extend him for a year. I believe he has 4 months remaining on his program so that he can do the PTSD program, the final phase. I would ask, Your Honor, not to, because he is so close to termination, even though he had alcohol missed and high blows at the end of 2020. I think he has been working very hard this year in trying to get his life on track. He needs medication. I would ask that he be allowed to be discharged or released from jail and go back to the program. He was supposed to be going back this morning, actually today at 10:30 a.m., but obviously he's in jail. They will let him report, I believe, as soon as he's released, to go back to inpatient for another 4 months. I would ask, if you're going to extend him, Your Honor, that it be extended to a maximum of 6 months to allow his completion turn in his completion certificates from the program and show to the court that he is worthy of your mercy on this.
State recommendation?
Your Honor, the state recommends revocation.
Okay, I've got some gaps in my understanding of how all this time went by.
Yes,
And
sir.
apparently nothing was going on. So I got some questions both from Ms. Headland and Ms. Gross. My understanding is the defendant went on probation on November 12th, 2020. Is that correct, Ms. Gross?
Yes,
And he's been reporting properly ever since. Is that correct?
yes, Your Honor. He lives out of county up in Dallas, so he has been reporting up there and through our out of county officer.
All right. And so there are a lot of these violations that occurred in 2020, and we're just having an MTR today. Did Mr. Clark become a fugitive, or why is it taking so long to get an MTR hearing on this individual?
Well, Judge, he was up in Dallas. The original MTR was filed in December of last year, and we finally just caught up with him. I don't even know where he lives now. The attorney mentioned that, he was transporting his auntie. Is that here in San Antonio? Was he here? Did that happen in Dallas and he got transferred here? I don't know.
Okay, but from the CSCD probation officer's perspective, even after he was in lockout and didn't have a functioning Smart Start mobile device, all that stuff, he still reported via Zoom or in some capacity on the web. Is that correct?
Yes, the warrant was active since December 15th, and he has been reporting.
And did any probation officer tell him during one of his reports, hey, there's a warrant out for you, there's an MTR, you need to turn yourself in?
That I don't know, Judge. I would have to inquire with them.
Okay, Ms. Headland, my questions for you involve Mr. Clark's voluntary treatment through the VA. I'd like to thank Mr. Clark for his service. Apparently, I don't know how it works in Dallas. I have to assume it's similar. In San Antonio, the longest actual inpatient program we have is called VS Arena, and it's 28 days. How long was Mr. Clark in any sort of actual inpatient? And by inpatient, I define that meaning he can't leave the building. He can't go anywhere, can't do anything. It's inpatient. They lock the doors and the windows. How long was he in an inpatient program with the VA?
Your Honor, my understanding is 1 month for the early phase, 2 months for the middle phase, but I would be happy to allow Mr. Clark to give you the specifics of where and what he did.
Mr. Clark, can you tell me about your inpatient? And then I assume after inpatient, they probably have continuing outpatient follow-on counseling. Is that kind of what you did?
Yes, sir. I went to the inpatient and I completed the early phase, and Miss Rebecca, my probation officer, I have been in contact with her. I told her she allowed me to complete the program. My son's birthday was September 22nd. So the inpatient program allowed me to take a break in between my early phase and my late phase. And I was due to go back today to complete my late phase. I was in total for 2 months and 3 days inpatient at the Sam Rayburn Veterans Memorial Hospital, and I was due to report back today to finish my late phase and my PTSD, sir.
Okay. Are you currently, as we speak, still in some sort of outpatient drug alcohol rehab program with the VA in Dallas?
Yes, sir. I attend the Audie Murphy. I just go to Audie Murphy for classes and for the outpatient classes, and it's just pretty much just like meetings, and I have a sponsor, and this is just until I return back to the Sam Rayburn Veterans Memorial Hospital, sir.
Okay, and were you arrested in Dallas and then brought down here? Is that what happened?
No, sir. I was actually in San Antonio, sir. My probation officer did. I talked to her and let her know that I was coming down here, and she said that once I completed the early phase, that I would have to check myself in. It will be 3 days. I would see the judge. They will reset it, and then I would be able to go back into the Sam Rayburn. But in between me trying to do that, I got into the accident. But I did return to the scene of the crime, and that's when I was arrested, sir.
I got you. Okay, and are you working in Dallas? What are you doing in Dallas?
Sir, I'm 100% disabled, so I'm unemployable, sir.
And you say you have one son, or how many children do you have?
Sir, I have one son. He's 13, sir.
Okay, but technically I mean, obviously you're in San Antonio today because you're in jail, but in a normal situation, you would live in Dallas. Would that be correct?
Sir, in a normal situation, I am homeless, sir. I was currently staying at the Sam Rayburn Veterans Memorial Hospital, and I just left from there like 2 months ago to go help my aunt out because she did have a stroke and things is not good with her. But we are working on getting her a caretaker because my mom wants me to go back into treatment. The intake lady, his name is Monica Kelly, and she is currently awaiting me there, sir.
Okay, let me back up. Did you just tell me you're homeless?
Yes, sir.
Aren't you making like $2,500, $3,000 a month disability from the VA for your 100% disability?
I just got diagnosed with 100% when I went in just now. So I wasn't always at 100%. I didn't get 100% and fully diagnosed until I went into the Sam Rayburn to be treated, sir.
All right. So at some point in time, you're going to be getting compensation for 100% disability. Would that be correct?
Yes, sir. I had received the compensation for that. So now I do. This is my second month getting paid at 100%, sir.
All right. State, let me ask you a question. Do you know what the status of the new case is as far as when an information may be filed on it, or if one's going to be filed on it?
Judge, I believe that an information will be filed in the future, and there is a complainant that is owed restitution in that case.
And Your Honor, based on what you just discussed with Mr. Clark, I'm sure Mr. Clark would agree to paying full restitution with a conditional dismissal if that's a possibility.
Mr. Clark, did you have insurance during this last, I guess, accident?
Sir, I was not driving. I don't have a vehicle, sir. The vehicle is in my aunt's name, and the only reason why I was driving the vehicle is because she had cataract surgery and she could not drive herself, sir.
Okay, well, this is a puzzle and it's got lots of pieces and they're not really fitting for me. So, Susan, if I want to defer my ruling on this motion to revoke probation to give the state and the defense time to look at the new case and this case together and perhaps craft an outcome that would be amenable for everybody. But I want to get Mr. Clark out of jail. I assume I still have the ability to put him on a bond, do I not? And let him out of jail, but this is all still pending and it doesn't violate the MTR?
I'm not sure how the bond system works in regards to this.
Well, currently he's remanded without bond is probably.
Your Honor, you can give him a bond. It will not affect the MTR because he's already been arrested on it.
All right.
That's
All
all.
right. State and defense. Here's what I'm suggesting. Let me get your input on it. I want to give Mr. Clark a $2,500 PR bond. I want to get him out of jail. He's welcome to go back to Dallas, and as long as he continues his treatment with the VA and we don't have any alcohol issues going on, that's one way. State, I would like you to look at the new case and expedite, if you're going to file it, expedite that. So the possibility exists, y'all may be able to craft an agreement on the new case that corresponds to what we're going to do on this case. And I want all this done quickly. Mr. Clark, I need copies from you for our probation department of all this rehabilitation stuff you have voluntarily done with the VA. So some sort of proof you were in this inpatient treatment 28-day program. And then if you've gone to AA meet, whatever you've done that has benefited you on trying to stop you from having an alcohol problem, that's what we need to see, because we don't have any of that right now, I don't think. Susan, is that correct?
No, Judge, I do have a letter from the VA in regards to the early phase program. He was certificate for completion on May 25th of 21. And that's through the VA North Texas healthcare system. So he has completed that. And I believe he said that he's in the midst of completing phase 2. So we wouldn't have any certificate on that.
Your Honor, I would like to clarify too that I believe Ms. Cavillo or Monica Kelly, who is the at the Memorial Hospital, I believe the probation officer does have his AA certificates and all the certificates of completion for the DWI education, the victim impact and all that. But I can gather all that as well and submit it to the court.
As I already stated, we have completion certificates for DWI education and victim impact panel. CATSNP program is the only thing that we don't have a certificate for. I also, Judge, have an admission certificate for this program. It appears to be a checklist where multiple people have signed for different things that he has done in the program.
All right, Mr. Clark and Ms. Hedlund, the textbook solution for this case is immediate revocation and a maximum jail sentence. The backup plan on that would be scram, and he's saying he's having money problems. If he's really going to be getting this VA disability, that should pretty much take the edge off of his money problem. But because he's been reporting, but because he has not been on any kind of alcohol monitoring device for a year, I guess, plus or minus, he would need to get on, and scram would be the preferred method. If we could get him on a Smart Start mobile, I'm sure he blows into it, but obviously he hadn't done that for a year. So I'm kind of running out of options. If Ms. Hedlund, do you want to go into a break room and chat with Mr. Clark about the possibility of going on a scram bracelet? Because if he's willing to do that, I'll just rule today and not revoke him and not sentence him to jail. And he can go back to Dallas. He's got to stay on a scram bracelet for the duration.
Judge, he's only on about 3 more weeks. And
we can extend him, can we not?
yes,
So we would extend him probably a year, maybe 6 months at a time. I don't know.
Yeah.
I need to see exactly what he's done in rehab. He may have done everything I wanted him to do without me even telling him to do it. I don't know what he's done exactly. So as long as he's been voluntarily trying to do this correctly, but I can't say that it's working. He's telling me it's working, but I don't have any proof because I don't have a alcohol monitoring device to look at the record of and say he's not drinking. So I don't know.
I know that they do test him and while he's in the inpatient. So I don't think he's gone anywhere other than Sam Rayburn.
If he's willing to go on scram and that costs $350 a month, and that's probably going to be for the duration, I will not revoke him and not put him in jail any longer. Let him out of jail. He can go back to Dallas and whatever programs he's not done, we'll just go from there. And y'all can try to craft an agreement on the new case. Would that be equitable to the defense?
Are you good with that, Mr. Clark?
Yes, ma'am. Whatever I have to do to get out today, because I need to get back on my medication.
All right. So is Mr. Clark willing to go on scram immediately?
Yes.
All right. State, is that okay with you?
State has no objection.
All right. Thank you. All right. Mr. Clark, in cause number 636-502, the court accepts your plea of true with an explanation to all allegations. I deny the state's motion to revoke your probation or to continue on probation with all prior requirements, altering, amending, adding the scram device within 5 days of you getting out of jail. They may put it on you before you get out of jail. I'm not sure how that works, but he needs to be immediately on the scram device, and the duration of that will be determined by how well he does on it. All prior requirements are still in place. Put him on weekly UAs in Dallas. Susan, what else do we need to do?
Judge, being that he is in this residential program and we do have proof of completion of phase 1, would you be willing to waive the CATSNP program in lieu?
Yes, absolutely.
Thank you.
And if he still has your Smart Start mobile device, you need to turn that back in so the company doesn't lose money on it.
I told him that earlier, Your Honor, so he will, and he does have it.
That's not going to be a problem. State, what else do we need to do?
Got it all, Judge.
All right.
And Judge, that was extend 6 months?
Yeah, let's go and extend 6 months at this time. And we can extend again if we have to. I don't want to. If Mr. Clark's doing as well in his VA program as he says he is, we just need confirmation of that. We need to show he's not drinking, and we'll let him graduate, from his probation timely in 6 months. Is that okay with you, Mr. Clark?
Sir, yes, sir.
All right, Mr. Clark, I have a question for you.
Yes, ma'am.
Can you verify that your email address starts with mark.clark365?
Yes, ma'am.
Okay, you will be receiving an email from me later today with your amended conditions and your referral to go and get the Scram device. It will have the address in the upper right-hand corner. The judge is giving you 5 days to get that bracelet on there. So as soon as you get that document, you need to go over there because they may have a waiting list. I don't know, okay? So let's say you get out tomorrow, you go over there tomorrow afternoon and they say they can't get it for 6 days. Just advise Ms. Calvillo, it will not be held against you that you can't get it within 5 days of your release because that is not your fault, okay? Just make sure that you keep in touch with Ms. Calvillo.
Yes, ma'am.
Do you have any questions?
Yes, ma'am. So do I buy, how do I get out today? Do I buy now or do I have to pay anything? I don't understand.
No.
He's giving you a personal recognizance
Thank you. I
bond.
appreciate it. Thank you. Thank you, ma'am.
No.
Thank you, sir.
No. There is no bond. The MTR has been heard, so you're going to be released outright, okay? But he's not going to get the paperwork until this afternoon in the jail. Their process is sometimes very slow. So it may take 12 hours. It may take 72 hours. We have no control over that. We'll get out as soon as they let you out, okay?
Thank you, ma'am.
All right.
All right, good luck, Mr. Clark. Thank you, Ms. Headland.
Thank you, sir. May we be excused?
You bet.
Thank you. Mark, call me whenever you're out, love, okay?
Your Honor,
Thank you, ma'am.
Yeah.
before you all leave, he has a $500 bond that he is going to have to pay unless you do a PR bond on the new offense.
Yes, please.
Yeah, let's do a PR and waive fees on that one.
Okay, I would write it down so the girls can send it and do what they need to do, Your Honor.
All right.
Thank
Okay,
you
Ms.
so much,
Headland.
Pat.
You're welcome.
All right. Good luck, guys.
Thank you.
Okay, thank you.
Mr. Garcia, you ready on Mr. Jurgens?
Yes, sir, I am.
And is there a new case pending on Mr. Jurgens also?
It predated the MTR, Your Honor.
Yeah.
And
And
is there
at large, Your Honor, right now.
And as soon as we finish the hearing today, I'm going to surrender him on that probably in the morning.
and there's an information already filed on the, I'm calling it a new case, but it's probably not a new case.
Yes,
I
Your Honor,
imagine
there
there
is.
is, Judge.
No, I
Right.
believe so. I'll double check while y'all.
All right. Well, that's apples and oranges, what we're doing today, correct? It's not an allegation on this one.
No, Your Honor.
It happened before. All right. It's cause number 660-512, State of Texas versus Jacob Jurgens. Representative Mr. Eddie Garcia, Mr. Jurgens and Mr. Garcia. I'm looking at two documents that purport to have your signatures on them. The first is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Mr. Jurgens, is this your signature on this document, sir?
Yes, sir.
And Mr. Garcia, as attorney for Mr. Jurgens, is this also your signature on this document?
Yes, it is, Your Honor.
And Mr. Jurgens, the next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Is this your signature on this document also, Mr. Jurgens?
Yes, sir.
And Mr. Garcia, as attorney for Mr. Jurgens, is this also your signature on this document?
It is, Your Honor.
This is a motion to enter adjudication of guilt and revoke community supervision. Mr. Garcia, my understanding is this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that accurate?
That is accurate.
Mr. Jurgens, in cause 660-512 on the motion to enter adjudication of guilt and revoke community supervision. How do you plead, sir? And your microphone is still off, Mr. Jurgens.
And we need to see your face, sir.
Mr. Jurgens, if you please, there you go.
Sorry. Oh,
Kind of adjust your picture.
true,
If you want,
true. I believe
Mr.
true.
Jurgens, you can see the top of your head. There you go. Now you're cooking. Is this your signature? I'm sorry. On these motion to enter adjudication of guilt and revoke community supervision, Mr. Jurgens, how do you plead, sir?
Mr. Garcia, what
True.
am I? True.
Court accepts the approve with an explanation. Ms. Gross, would you please advise the court and the parties of the status of Mr. Jurgens' probation? I remind you, you're still under oath.
Yes, Your Honor. Mr. Jurgens has been reporting as directed. We last saw him on October 18th of 2021. He has paid $454 towards his fees. He has a balance of $375 and he is current at this time. He has not completed any of his 36 hours of community service. He has failed to submit to drug testing on 3 occasions, and we have no proof of enrollment or completion of a firearm safety course. This is his first violation report, first MTR. His criminal history does include an arrest for terroristic threats, which is pending, but it did occur prior to probation. His officer is recommending that we increase the UAs to a weekly status and that the defendant shows substantial compliance within 30 days.
Okay, defense, what are you requesting?
Judge, I have a receipt in front of me that I can forward to his probation officer. Perhaps Mr. Jurgens can provide it himself, where he has paid $288 for his community service. So I think that clears that. And also a screenshot that was sent to me that he has enrolled in the handgun safety course at the Handgun Safety Training Corporation on Fredericksburg Road. And he should be able to start that pretty quickly here. So we'd ask the court to go along with the probation officer's recommendation and get him back on board.
State recommendation. I'm sorry, Susan, go
State-
ahead.
I was just going to advise the attorney that $288 would not cover the complete amount of community service, as it is $10 per hour for the
Okay.
record.
Okay, I had calculated it based on what he gave me at $8 an hour, so he still owes a little bit, but he has shown substantial compliance at least by paying $288.
All right, state recommendation, please.
State agrees with probation's recommendation, Your Honor.
Susan, what were the terms of Mr. Jurgens' original probation? I know it was a deferred, but he had, what was the fine amount and what were community service amount? And I understand the the firearms course, and what else?
Yes, Judge. His original fine was $200. And he was ordered to complete 36 hours of community service and do a firearms safety course.
And we're missing UAs. Eddie, what's going on with that?
Well, Judge, based on what the probation officer said, I don't think that was a condition of his probation. So I'm a little confused by that, but nevertheless, I mean, he's a full-time student at St. Mary's, and if he were ordered to do that, perhaps it was just an oversight. But if the court wants him to do UAs as recommended on a weekly basis, he has no problem with that.
Okay, every probationer in County Court 6 and the Bexar County Veterans Treatment Court is subject to at least monthly UA. So that is a
Understood, Your
condition
Honor.
of his probation.
And it
Understood.
is a condition of his probation, and he did receive a copy of that.
Okay, then it's my oversight.
And that's actually on the basic conditions that are issued to every defendant placed on probation in Bexar County.
Okay, it was just excluded from what you told the judge, so I understand now.
We have any actual UAs on Mr. Jurgens in the term of his probation?
Negative, Judge. He's never appeared for a drug test as ordered.
Mr. Jurgens, if I send you out for a UA today, you going to be positive for anything colorful?
I'm not sure, sir. I don't think so.
You don't think so? You're going to be positive for marijuana?
I've been around people that smoke it, but I don't smoke it.
Okay, I'm sorry, sir. I'm having a hard time hearing you.
We can't
I've been
see
around. I've been around people that smoke it, but I don't smoke it.
All right, we'll assume that that's sort of maybe.
And your conditions also state that you're not to associate with people of harmful or disreputable character, and that includes people that use drugs. So that would be another violation of your probation.
All right, here's the deal. Mr. Jurgens, in clause 660512, the court accepts your plea of truth and explanation. I grant the state's motion to revoke your deferred adjudication and probation. I adjudicate you guilty of the offense of unlawfully carrying a handgun. I sentence you to 1 year in the Bexar County Jail, probated for 6 months, assessing a $500 fine, which is $300 more than the last time, plus court costs, 36 hours community service, weekly UAs. Mr. Garcia, show me 4 clean weekly UAs in a row, and I'll put him back on monthly UAs. Firearm safety course and DOEP course. Susan, what did I miss?
I believe that covers it, Judge.
State, what did I miss?
I think you got it all, Judge.
All right.
Mr. Jurgensen, Mr. Garcia, I will be sending a new application for probation that needs to be filled out as soon as possible so that it can go to the probation office.
Okay,
Eddie, if, as, and when Mr. Jurgens were to go on probation for the terroristic threat case 670-207, I will run this concurrent, so that's not going to be a problem on that one. So hopefully y'all can work something out. State, put
Okay,
that one
good.
on your front burner and stay in touch with Mr. Garcia and see if y'all can get that worked out.
Judge, will you recall the warrant on this MTR? I didn't get a chance
Absolutely.
to.
We're recalling all prior pretrial services bond conditions.
All right, and Mr. Jurgens, you are starting probation all over again. So you will be receiving the paperwork from Ms. Benavides today. You need to fill that out and return it today. It will go to the probation department and they will be in contact with you either via email or telephone, okay? If you have not heard from them by Tuesday morning, you need to call them at 210-335-7446 and advise them that you need to go to orientation. Okay, again, that number is 210-335-7446. If you fail to go back for orientation, you're going to be right back where you're at right now with another warrant. Okay, do you have any questions?
Okay, yes, ma'am. And the number was 210-335-7446.
Yes, that is correct. So if you haven't heard from them by Tuesday morning about 10 o'clock, then you need to call that number and tell them that you need an orientation time.
Okay, yes,
Or
ma'am.
you can
Thank
have
you.
your attorney get in touch with me if you can't get in touch with them.
Yes, ma'am.
All right.
Thank you.
Ms. Gross,
All right.
I want Mr. Jurgens to submit a UA by 12 o'clock noon tomorrow. That means within 24 hours. Mr. Garcia, he can do it this afternoon. He can do it tomorrow morning. I don't care. Ms. Gross, tell him how to do that.
Okay, Mr. Jurgens, I'm going to send a message to your officer right now to put you in the computer system. And as the judge stated, you have 24 hours to go over and drop a sample at the lab. Okay?
Okay. Yes, ma'am.
So I'm gonna send her a message right now. Call her maybe after lunch. And you should have the address because you've been told to go there 3 times before and neglected to do so. But you can touch base with her. She'll put you in the computer so that you can go do that within the next 24 hours. If you fail to do that within 24 hours, then again, the judge is gonna issue a warrant for your arrest.
All right.
Okay, yes, ma'am.
Got any questions, Mr. Jurgens?
No, sir. Thank you.
Okay. Thank you, Mr. Jurgens. Good luck. Thank you, Mr. Garcia. Y'all are dismissed.
Yes, Your Honor. Thank you very much.
You bet.
Thank you.
All right. Are we ready on Miss Martin, Mr. Lara? Guillermo, are you with us, Mr. Lara?
Yes, Judge, I apologize. I was watching some news.
No problem. Any news out there we need to know about?
No, Judge, it's the same thing. This Shiba Inu coin is going insane today, though. It's up over 60%.
Oh my goodness. Okay, this is cause number 649194, State of Texas versus Kimberly Martin, represented by Mr. Guillermo Lara. Miss Martin and Mr. Lara, this is a motion to revoke community supervision. The first 2 documents I have for you to identify your signatures on. The first one's entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Ms. Martin, is this your signature on this document, ma'am?
Yes, sir.
Thank you. And Mr. Lara, as attorney for Ms. Martin, is this your signature on this document?
Yes, Your Honor, it is.
Thank you. Next document I have is entitled Trial Court Certification of Defendant's Right of Appeal. Is this your signature? Oh, and then it's marked as a revocation of the defendant's community supervision. and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Ms. Martin, is this your signature on this document also, ma'am?
Yes, Your Honor.
And Mr. Lara, as an attorney for Ms. Martin, is this also your signature on this document?
Yes, Judge.
As previously stated, this is a motion to revoke community supervision. Mr. Lara, my understanding is this is an uncontested motion to revoke community supervision. Is that correct?
Judge, yes, that is correct. After speaking with Ms. Martin, she'd like to enter true to condition number 16, Judge.
Fair enough. So at this time, Ms. Martin, on the motion to revoke community supervision, how do you plead? And my understanding is it's true with an explanation to condition 16. Is that correct, Ms. Martin?
Yes, Your Honor.
All right. Ms. Gross, I remind you, you're still under oath. Would you please advise the court and the parties of the status of Ms. Martin's probation?
Yes, Your Honor. Ms. Martin has been reporting as directed. We last saw her September 17th, 2021. Her case is paid in full. She has completed all 48 hours of her community service. She is currently on Smart Start Mobile testing 6 times per day. And at this time, she has 9 skip tests and 0 BRACs. She failed to submit to drug testing on 2 occasions. She has had 8 negative drug tests and 17 diluted drug tests. She has completed a TAP evaluation as well as DWI education and victim impact panel. This is her 2nd violation report, 1st MTR. She has no criminal history, and her officer is recommending that she be continued on probation and placed on weekly drug testing.
And how many diluted drug test samples did you say we have?
17, Your Honor.
Oh, let's start there. Ms. Martin and Mr. Lara, can you explain that?
Judge, as far as the 17 diluted samples, Judge, I think there's some issue with her underlying health condition. When she first started the DWI court program, Judge, it was clearly made known to them that she has an underlying health condition. Now, that underlying health condition involves her kidneys, and it does affect her ability to have, again, when she goes and does these drug tests, she's on medications. They should have all that documentation when she first joined the DWI court program. Now, the issue is when she transferred over to County Court 6, that's when things started getting a little crazy. And that's when we started having these issues. Now, the issues that we're having is it's not noted, and I'm not sure if her present probation officer, Ms. Hernandez, is aware of those medical documents, which she's already provided to the court in that initial court proceeding. Now, she's on medication. Not only that, she's required to drink an excessive amount of water because of that medication and her underlying condition. And in fact, Judge, she was tested there in the jail facility yesterday because she was feeling dehydrated. She was having other serious conditions. So they took her in, had her tested, again, came out diluted, Your Honor. So I think there may be some misunderstanding or some issue there with what's going on with the samples and the testing, Judge, just to address those issues. So we think there's some concern on that issue, Judge.
And then what prescription is she on that's testing for amphetamines?
ADHD meds. I have ADHD medication. I take Adderall. I take 30 milligrams, but I have renal failure. But I was only informed that I had 2 dilutes. I've never been told that I was told on the 10th and the 29th, sir. But I do take, I have a kidney specialist. I was complete renal failure. So my kidneys work at a very low percentage. So I don't produce creatine. I do take, it's Abuspartin. They're not able to get it for me here. And it has a diuretic in it as well. But all of that all my medical records were submitted when I first got put into the program.
And Judge, we do have proof of the amphetamine salts, which are testing positive. We do have proof of that in our records.
Do you know if this was an alcohol related DWI or a drug and alcohol related DWI?
It was just alcohol, sir. I've never used drugs. I don't have any history of any of that.
Were you taking your medication at the time, the amphetamine salts?
Yes, ma'am.
So that would have had an effect, and the alcohol would exacerbate the amphetamine salts. So it could have been a combination of both, Judge, even though she was only charged with the alcohol side of the DWI.
Yes, I've been on the Adderall for years.
Mr. Lara, there are two options. A is revocation in jail and B is a scram bracelet. Is she willing to volunteer to pay $350 a month for a scram bracelet?
I have
Judge,
33 days.
Miss Martin, let me, but Judge, I believe we would be inclined to do the scram bracelet, Judge, in lieu of the breathalyzer, Judge, and for it to remain to be completed on December 3rd of 2021. That's what she wants, Judge. If that's what Ms. Martin wants, if it to be ended on December of 3rd, 2021, then she'd be more than happy to do the scram to show the court that she's not consuming any alcohol.
Yes.
And there are going to be absolutely no violations on that scram device, Judge.
Absolutely.
Okay, I show we're going on probation December 3rd, 2020 for a term of 12 months. I have no intention of extending her. However, if the defense is willing to do scram until the 2nd of December, 2021, that'll take the edge off of my concerns for her continuing drinking and this diluted stuff. I also need a letter from her doctor that tells me what her medical condition is, why we're getting all these diluted tests. I heard her explanation, but I'm still not clear on if that's valid or not. So can y'all get me a letter from a doctor that explains what's going on and why she's giving us diluted UA?
Judge, if we could have a week after her release for her to get those documents, if you give her some,
how about 10 days, something like that? Would that be good?
that should be good enough for us to get those documents to you, Judge.
All right, state recommendation.
The state would agree with probation's recommendation on the scram bracelet.
Fair enough. Susan, is there any other viable testing other than a urinalysis test to test for illegal drugs?
We can put her on a drug patch.
And explain how that works.
It's like a nicotine patch that you wear on your arm, and then you go in and they rip it off and they send that off for testing and slap on a new one.
And how often does one do that?
I want to say it's a weekly thing, Judge, but don't quote me on that.
And can you determine methamphetamines and cocaine and stuff by that patch?
Yes.
Defense, is that something that you would think would be reasonable for a while under the circumstances to prove that she's not using illegal drugs?
Yes,
Your Honor.
I'll do whatever.
All right. What is that patch called, Susan? Is it a drug patch?
Yes, Your Honor. Drug patch. Or drug patch testing.
And Judge, would she'd have to orchestrate that with her current probation officer? Is that my understanding?
Yes, she will have to get with her officer, and she's actually going to have a new officer.
Perfect.
I'm not sure who that is, but I can give you the number to her manager. Her manager is Miss Jennifer Vaughn. And her phone number is 210-335-7440. So contact her when you get out of jail. She'll give you your new officer's name, and she'll give you instructions on how to get set up on the drug patch.
So it's the drug patch and not the scram?
Oh.
No, you're going to do scram too, but judge hasn't given his final ruling yet.
All right, here's the final ruling. In cause 649194, Ms. Martin, the court accepts your plea of true with an explanation to condition 16. I deny the state's motion to revoke your community supervision, or you continued on community supervision with all prior requirements and no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Would that be necessary, ma'am?
No, sir.
Good answer. altering amending conditions, adding the scram cam, alcohol detecting ankle bracelet within 10 days, and adding a drug testing patch whenever that's available. And she's only got, what, 2 more months of probation? So she'll continue the scram and the testing patch for those 2 months of probation. And she's doing okay on all other areas. She can turn in her Smart Start mobile device. And that's
After
all I
she's
got.
scrapped.
After she's active on scram. Susan, what did I miss?
Were you gonna make it a condition that she provide a letter of explanation from her doctor on
Yeah.
her kidney issues?
I don't know that we need to make it an order. They're just gonna provide, court needs a letter, a doctor's letter on this UA dilution business, okay?
Yes, Judge.
All right, Ms. Martin, I will be sending you documents via your email. And does your email start Kimberly Martin 33?
Yes, ma'am.
All right, I will be sending those documents to you today, so they will be in your box by the time you get out of jail, which will probably be tomorrow. You need to sign those documents, and in that email, I will also put Ms. Vaughn's phone number, and you need to contact her so that she can get you set up to get that drug patch. And then also it will have the scram referral so that you can go over and get that. And as you heard me say earlier, there may be a waiting list. I don't know, but you need to at least contact them as soon as you get out. Do you have any questions?
No.
All right. Good luck to you, ma'am.
Thank you.
Right. Y'all are dismissed. Thank you. Mr. Ross, are you ready on Mr. Riviezo?
We have a breakout room?
John, can you hear me?
Yes, I'm ready.
Oh, no, not Mr. Brendel, Mr. Jonathan Ross.
Yes, Your Honor. I was actually going to see if I could maybe touch. I'm in here on a kind of like renegade Zoom from district court on a second one. I was going to see if I could touch base with the state, maybe talk him into withdrawing this. He just got the wrong ignition device. He's already got an appointment to get the right one.
All right, bear with me. I'm having a hard time understanding you. Are you ready to go forward on Mr. Riviezo right now, or have you got a conflict?
If I could touch base with the state, Your Honor, perhaps I can convince him to withdraw the MTR.
All right, you just wait till the end of we get to everybody else, and I'll give you a chance to chat with them. But you're supposed to be doing that before we get to these hearing dates, okay?
Fair enough. Fair enough.
All right, Mr. Engelke, are you ready to go forward on Mr. Arguello?
Yes, Your Honor.
All right, it's cause number 575363, State of Texas versus Alec Arguello, represented by Mr. Keith Engelke. I have 2 documents initially. This is a motion to enter adjudication of guilt and revoke community supervision. Mr. Arguello, I have 2 documents for you to identify your signature on. The first is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, sir, is this your signature on this document?
Yes, sir.
Thank you. And Mr. Engelke, as attorney for Mr. Arguello, is this your signature on this document?
It is, Your Honor.
Thank you. Ms. Benavides, my copy of the document does not have a date for Mr. Arguello and Mr. Engelke's signature. Administratively, we just can ensure that that is dated.
Yes, Your Honor.
Okay. And Mr. Arguello, the next document I have is entitled Trial Court Certification, a defendant's right of appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Is this your signature on this document also, sir?
Yes, Your Honor.
Thank you. And Mr. Engelke, as attorney for Mr. Arguello, is this also your signature on this document?
That's correct, Your Honor.
Thank you. And my understanding, Mr. Engelke, is that this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
It is, Your Honor.
Mr. Arguello, in cause 575363 on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir?
True.
Thank you. And Ms. Gross, I remind you, you're still under oath. Would you please advise the court and the parties of the status of Mr. Arguello's probation?
Yes, Your Honor. Mr. Arguello has performed very poorly on probation in that he only ever reported one time. We last saw him August 27th of 2018. He never paid anything. He has a balance of $1,317. He did not complete any of his 36 hours of community service, never went for a drug test, We have no proof of enrollment or completion of the theft class. This is his first violation report, first MTR. His prior arrest history includes a failure to ID and criminal trespass in possession of a controlled substance, penalty group 3, less than 28 grams. His officer is recommending that his probation be terminated satisfactory if he pays in full. Otherwise, the officer would like it to be reset for 30 days for the defendant to pay in full and complete the theft class.
State recommendation.
The state agrees with probation's recommendation, or in lieu of that, we would recommend revocation and a judgment satisfied.
And defense, what are you requesting?
We're requesting the revocation and the judgment satisfied.
Mr. Arguello, in cause 575-363, the court accepts your plea of true. On the motion to enter adjudication of guilt and revoke community supervision, I grant the state's motion to revoke your deferred adjudication probation, adjudicate you guilty of the offense of theft, $100 to $750. I sentence you to 6 months in the Bexar County Jail, assess a $2,000 fine plus court costs, credit for time served, time and money to run concurrent. Your report to the Bexar County Jail at 9:00 a.m. on Friday, October 29th, 2021. However, if you pay in full the $1,317 you owe the probation department before that date and time, I will waive your jail sentence. Anything further from the state of the defense on Mr. Arguello?
I believe the state said something, but she's muted.
I'm sorry, Mr. Engelke, say again.
I believe the state was trying to speak, but she was muted, so I didn't hear her.
Said nothing further from the state.
Oh, sorry.
And Mr. Arguello, if you intend on making that payment, you need to make it well before your report date for jail. You can pay it at the probation department, which is across the street from the jail at 207 North Kamau. So you would pay the $1,317 plus a $2 processing fee. Okay. As soon as you make that payment, you need to let your attorney know so that he can let either myself or the judge know, so that the judge can remove that jail sanction.
Okay.
Not a sanction, it's a sentence, but that's all good. All right. Any further questions?
Yes, I do have a question. I didn't hear the report date.
And once again, I'm having a very difficult time understanding you, Mr. Engelke. Your microphone is doing funny things. Say that one more time, please.
When is his report date?
The report.
29.
Report date is this coming Friday morning, October 29th, 2021 at 9:00 a.m.
Okay, thank you.
Yes, sir.
May we be
All right.
excused?
You bet. Thank you very much. And is Mr. Locke still with us? He had to go to a felony thing, I think. Okay. Ms. Gonzalez, are you ready on Mr. Juarez?
Yes, Your Honor, we're ready.
This is cause 655-767, State of Texas versus Jacob J. Juarez Jr., represented by Ms. Sally Gonzalez. And this is a motion to enter adjudication of guilt and revoke community supervision. Mr. Juarez and Ms. Gonzalez, I have two documents for you to identify your signatures on. The first is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Mr. Juarez, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. And Ms. Gonzalez, as attorney for Mr. Juarez, is this your signature on this document?
Yes, Your Honor.
Thank you. And Ms. Benavides, for administrative purposes, my copy of this document does not have a date on it. Please ensure that it is dated, I assume today's date when they would have executed this. And the next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Is this your signature on this document also, Mr. Juarez?
Yes, Your Honor.
Thank you, sir. And Ms. Gonzalez, as attorney for Mr. Juarez, is this also your signature on this document?
Yes, Your Honor.
Thank you. My understanding is this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct, Ms. Gonzalez?
Yes, we're pleading true with explanation.
Fair enough. Mr. Juarez, in cause 655-767 on the motion to enter adjudication of guilt and revoke community supervision. How do you plead, sir?
True with an explanation.
Fair enough. And Ms. Gross, would you please advise the court and the parties of the status of Mr. Juarez probation? I remind you, you're still under oath.
Yes, Your Honor. Mr. Juarez has been reporting as directed. We last saw him on October 21st, 2021. He has paid $544 towards his fees. He has a balance of $787, and he is current at this time. He is currently testing on Smart Start Mobile at 6 times per day. He has had 1 skip and 0 high bracs. He has completed DWI education, victim impact panel, in the CATSNP program. He, however, has had 4 positive drug tests for marijuana, 2 negative drug tests. His last 2 were negative. His prior arrest history is for an unlawful carrying of a weapon, and his officer is recommending that he go to SATF for 120 days, followed by aftercare.
And this is his second MTR, is that correct?
Yes, Your Honor.
Okay. And Ms. Gonzalez, what are you requesting?
Well, actually, she has updated her information since our last hearing. So she has some of the things that he's completed that they had on the violation report that he did not, like his community service hours. He completed October the 19th. He's fine on that. And the violation 17, I guess she has that information. He does have that certificate. But she mentioned 4 drug failures, and I only have information on 2.
It's a cumulative history as provided to the court, and at the time the motion to revoke was filed, he had not completed those classes in community service that are alleged. He completed those after the motion was filed. That's why they're on there.
Yes. On violation 2, what are the dates of that you're stating he failed drug tests? Susan?
I'm looking.
Sorry.
July 16th of 2021, August 27th of 2021, and then he was also positive again on September 23rd, 2021.
Okay, well, moving forward, Your Honor, again, I only had on the violation report, I have the August and the September. That was the only one. So he has substantially complied with everything. A few things were completed after the report came in. He's is currently working at the Aqueducts bar, and he's in the process. He's in the, so since last week, you no longer work there, and then now you're completing your application to work at the theater at the Rim. So in explaining that, he recognizes that the bar is a bad environment for him. He thinks that it may have something to do with his negative or his failing some of his drug tests. He does want to better his life. He can't be without income. He helps support his 2 younger siblings. And then taken into consideration how much he's paid and all the things he has complied with, we are asking that his probation not be revoked. Furthermore, he's struggling to communicate with Crystal Hernandez. And if he is extended his probation, he feels that it would be better for him if he had a different officer to report to. She hasn't been responding to his emails, and he just isn't comfortable with reporting to her. He's not sure that she's getting all of his information and reporting it correctly.
State recommendation.
The state recommends adjudication and that he be placed on regular probation and amend his conditions to include the DOEP class.
And Susan, could you advise us on what the original terms of Mr. Juarez deferred adjudication probation were?
Yes, Your Honor. He was originally ordered to do 24 hours of community service, which he has completed. He was ordered to do DWI education, victim impact panel, and DWI education, or I'm sorry, CAPSNet program, which he has completed all 3 of those. And then, of course, the regular drug testing. And his original fine was $500.
All right. Everybody agree that marijuana is our primary issue on this case? Would you agree, Ms. Gonzalez?
Yes, Your Honor.
Mr. Juarez, can you stop smoking marijuana because you're not showing me you can?
Yes, Your Honor, I can.
You had one MTR before and you told me the same thing. I don't.
No, Your Honor, I know, I understand. I remember. When I came to you last time, I promised you that the next time I would see you, I was gonna have 4 clean drug tests and I was gonna have 30 days without any missed blows. And I intended to keep that promise. Like Ms. Gonzalez said, I really do want to better my life. I'm changing my job. I wholeheartedly understand that that is a bad environment for me to be at. I have stopped smoking, but the people around me seem to be getting me in trouble. So I'm leaving the environment. I'm just leaving the whole environment because I do want to be a better person and I have stopped smoking. I just hope that you can see that as I've substantially complied with all of my probation. I really am trying, Your Honor. I don't take you as a joke and I don't take the circumstances I'm in as a joke either.
All right, here's the plan. Mr. Juarez, in cause 655-767, the court accepts your plea of truth and explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of driving while intoxicated. I sentence you to 6 months in the Bexar County Jail, probated for 6 months. Assess a $500 fine plus court costs, 24 hours community service. Community Alliance for Traffic Safety New Intervention Program, DWI Education Program, DWI Victim Impact Panel. Add weekly UAs that were not already on it. Add Community Alliance for Traffic Safety Intensive Outpatient Program instead of DOEP. Credit for any programs he's completed, monies he's paid, community service hours performed. And I don't have the legal authority to tell you this, but you need to find some new friends, Mr. Juarez. They keep getting you in trouble. But it's
Judge,
you ultimately that makes that decision. So, you got to come up with a plan.
Yes, Your Honor.
Judge, are you going to also order the Smart Start mobile device, and for how long?
Yep, Smart Start Mobile until, how long has he been on it already?
He has been on it, it looks like since June of 2021.
Have we had any violation?
Just some skip tests, I believe. I would have to review his records to see if there's any high brax.
Let's say Smart Start Mobile at 4 blows a day for 3 months.
All right, he's currently testing it 6 times a day.
How long has he been on 6 times a day? Since June?
Let's see.
I believe since September.
I'm looking for that date, Judge. It's
And
coming
what
up.
I'm looking for, am I looking for a clean 30 days without missing any blows at 6 blows a day and no positives for alcohol during that time? That's what I'm looking for.
Right. It looks like since the first week of September, he has been at 6 blows per day. I'll have to go to the Smart Start website to pull up his most recent report because it hasn't been generated. Give me just 1 minute.
And what is it we're waiting on? I'm sorry.
Checking his last month's report. It's coming up right now. It looks like he has had one skip test on October 23rd and one on October 12th. And one on October 3rd. So 3 skips in the last month.
Bring him back down to 4.
Okay, so Smart Start Mobile for 3 months.
At 4
at
blows
4
a day.
times. Okay,
And weekly UAs. Once he shows me a clean 4 weekly UAs in a row, starting today, we'll take him off a weekly, put him back on monthly.
all right, Mr. Juarez, you're gonna be starting probation all over. Ms. Benavides will be sending you and your attorney some paperwork today. You
I've
need to-
already sent it.
Awesome. So you need to fill that out, sign it, and send it back immediately. And then the probation department will be reaching out to you. If you haven't heard from them by next Tuesday morning, you need to call this number, 210-335-7446, and let them know that you need an orientation date. If you fail to go to that orientation, you're going to end up with another motion to revoke, and you're going to be right back here. So make sure that you follow through with that. And again, that phone
Can you-
number is 210-335-7446.
Okay. Yes,
Okay.
ma'am.
I'm going to reach out to your officer and let her know to drop your Smart Start mobile testing to 4 times per day. And actually, it's going to be her manager. So let me give you her phone number. It's Miss Vaughn.
I have Mrs. Vaughn. It's 335-7440, right?
Okay, yes. So she'll probably do it late this afternoon. So if you don't get an email or a text from her with your new blow times, call her before, well, call her about 5 o'clock if you haven't gotten something from her by then in regards to your new test times. Okay, but make sure you go to orientation.
Yes,
Any
ma'am.
questions?
No, ma'am.
Ms.
And
Gonzalez, hang on a second, Susan. I want you to have about a 3-minute conversation with Mr. Juarez and explain to him the only reason he's not going to jail for 6 months today is because you convinced me he gets one more shot. I'm out of options. No more tools in my toolbox except jail. Do we understand each other, Mr. Juarez?
Yes, Your Honor. Thank
Next
you so
time
much, Your Honor.
Next time you start hanging around people with green leafy substances burning, you might want to think about that, okay?
I've cut them all off, Your Honor. I'm tired
right,
of
you're
going
the
through
man.
this. I want to show
Go ahead,
y'all
Susan.
better.
Thank you. Susan, go ahead. I apologize.
Is he to receive credit for all done and paid prior?
That's correct. That's
Please
correct.
note that on your record as well, Judge.
All right. Good luck, Mr. Juarez. Thank you, Ms. Gonzalez. Y'all are.
Ms. Gonzalez, if
Your
you
Honor.
want to talk to him, you can go into a breakout room. Let me know, yes or no.
Yes, ma'am. Thank you. And then
Go back into 8 and I'll put him in 8.
All right. Thank you.
And Mr. Locke, give me about 2 minutes to go get a document, and I'll be right back. We're ready for you. Will that work?
Yes, Judge, I have to be in the 379th. I'm going to run into the 379th. Can you send me a text when?
I mean, yes, can do.
Okay.
And Mr. Ross is ready when you're on. Well, I had low batteries, so I had to plug in for a while when I went out and back in. So that was my thing. Let me know, because I don't see you. Okay, okay, bye.
Mr. Riviezo, are you feeling okay? You're muted, Mr. Riviezo. That's all right. That's all right. It's not serious. It's fine.
Now we're missing Pat and a probation officer.
I'm here, Your Honor. Susan was kicked off. She tried to sign back in. It didn't work. What she's trying to do right now is reboot her computer. She didn't know what happened. It just
Use her cell phone as a backup.
I asked her that. She said she didn't know whether she had Zoom on it. We will have a discussion about having backups.
All we need is her voice. We know what she looks like.
Okay, I'll tell her. Well, the thing is, she wouldn't be able to come into Zoom. That would be it. She could call me and use it. Your Honor. Let me tell her.
We may have to do that.
Okay.
Why can't she sign into Zoom with her cell phone?
If not, judge says use.
Okay.
Your Honor, can you hear her? Say something.
Hello, Judge.
Barely. You can't sign into Zoom on your cell phone?
No, I don't have Zoom on my cell phone.
Okay, well that, right now we hear you just fine.
Trying to log in, but we'll do this for now.
Mr. Ross, you ready to proceed?
Yes, Your Honor.
All right. Back on the record on 6299957 Theta, Texas versus Michael Riviezo, represented by Mr. Jonathan Ross. This is a motion to revoke community supervision. Mr. Riviezo and Mr. Ross, I have two documents for you to identify your signatures on for me. The first is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Mr. Riviezo, is this your signature on this document, sir?
Yes.
Thank you, sir. And Mr. Ross, as attorney for Mr. Riviezo, is this your signature on this document?
Yes.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Mr. Riviezo?
I'm not sure. Yeah, yes. Yes, I'm just having panic attack problems, sir. That's all it is. Yes.
You want to take a break for a little bit, Mr. Riviezo? What can we do?
I'm fine. I need to get through it. It's fine.
All right. Is this your signature on this document, Mr. Riviezo?
Yes, sir.
Thank you. And as attorney for Mr. Riviezo, Mr. Ross, is this also your signature on this document?
Yes.
Once again, this is a motion to revoke community supervision. And Mr. Ross, my understanding is this is uncontested. Is that correct?
That is correct, Your Honor.
All right. Mr. Riviezo, in cause 6299957 on the motion to revoke community supervision, how do you plead, sir?
Yes, with a reason. True with reason.
True with an explanation. Fair enough, sir. Ms. Gross, would you please advise the court and the parties of the status of Mr. Riviezo's probation? I remind you, you're still under oath.
Your Honor. He's not yet reported, as he was just placed on probation on September 1st. He did go to intake and sign his conditions. He has not yet made any payments. He has a balance of $1,235, and he is delinquent $118. We have no record of any of his 48 hours community service having been completed. And we have no record of enrollment or completion of the Victim Impact Panel, DWI education, or CAPSNIP programs. He was ordered to get a Smart Start mobile device. He had instead obtained an Intoxilock device. He was testing 4 times per day on that device. And between September 30th and October 25th, he had 74 skip tests. It is my understanding that he now has an appointment to obtain a Smart Start mobile device on November the 3rd. And his officer is recommending that he be continued and that he obtain this device as directed on November 3rd and that he enroll with all of his programs within 14 days.
Okay, Mr. Ross, what are you requesting?
Yes, Your Honor. This is just it seems to be a misunderstanding. I provided proof to the state that he saw that device on the list that probation got him and thought that he could get that device. He did get that other device, the IntoxLock device, but he's already scheduled to get the new one. So he's meaning to get everything straightened out. He's already got that appointment arranged. So if you want to just continue him and allow him to get on that, he'd be very appreciative, Your Honor.
Okay, I guess my concerns are he apparently has a tremendous amount of skips on the device he currently had. Is that correct?
Yes, Your Honor. He had 74 skip tests.
I didn't know how to use it, and I was trying to find that was the reason. That's all I have, because I've been living in Haven for Hope. I've been homeless, and I've been trying to calibrate the device. And on Thursday, tomorrow was the day we was gonna go fix it. And me and my sisters working to help me do it. So, I mean, I'm trying to get my stuff back together. So in Haven for Hope, I've been getting my housing and birth certificate and stuff. So I was in the middle of doing all that, and I'm sorry. And
Okay, sure, take your time.
And I was in the middle of doing all that, but I had a house that anyway, I was in the middle of doing all that. I was trying to figure out the device. I suffer from mental illness, and so that's all I got. There was no misses for any other than that.
Judge, I do believe he is under conservatorship through his sister, and she is acting as his payee for his accounts. And according to his officer, she has been instrumental in trying to assist her brother in setting up a new appointment with Smart Start and making sure that he gets switched over to that device. And if the court continues him, I would just advise Mr. Reviziero to make sure that when you go to Smart Start, make sure you spend some time with them and make sure that before you leave that you have a clear understanding on how to use the device and that you understand the test windows. You're going to have a 2-hour block in which you can make your blow times, okay? But make sure you have a clear understanding before you leave Smart Start on how to use the device so that you don't end up back here.
Okay.
Ms. Galloway, I got a question. This gentleman, Mr. Riviezo, is charged with obstruction of a passageway, roadway, waterway. Normally, someone gets there by virtue of started out with a DWI and it was reduced. Is that what happened to this one? Or do you know how that's what happened? Okay. And state recommendation.
Your Honor, that is what happened. Mr. Ross did provide proof that the defendant does have an appointment to obtain the correct device. And so at this time, the state would recommend continuing the defendant and agree with probation's recommendation.
Hey, Mr. Riviezo, are you getting any help for your mental health issue?
I am while I'm in Haven for Hope, and I see my doctor on the 12th on the next month. I mean on the 7th of next month. I take medication and all that stuff. It's just been hard since I haven't slept since I've been in here. So I'm a little bit weakened. So the whole process, you know. So I've been here for like 2.5 days. So I just been trying to adjust again, you know, and I'm just had a panic attack. That's all.
I understand, sir. Hey, sir, are you getting disability? I'm trying to
Yes.
determine how you're going to pay for this.
Right. Right, disability, 1,060 a month. And I was starting all my stuff in when I got into Haven for Hope, and it just got messed up when I got the wrong device and such as.
Yes, Your Honor, I believe his sister is the payee on that. And
Okay.
and
Hey,
she
Mr.
is
Ross.
helping. Yes.
Mr. Ross, in your discussions with Mr. Riviezo, do you feel like he's going to be able to comply with the requirements of probation?
I believe so. Yes. He's just a little stressed right now. When I visited him in jail, he was cogent. He was much calmer. He does have his sister that's helping him out through this. So it seems pretty organized. I think he just got a little confused about the particular direction about the Smart Start.
And Mr. Riviezo, have you been in jail 3 days? Does that sound right?
Yes.
And Judge, the officer did recommend that he go on a Scram device and that he also attend AA meetings for 90 days.
If he wants to do that, he's welcome to do the AA meetings. If that'll help you, I'm not going to order it. I mean, you can discuss that with Mr. Ross and find out what's in his best interest. Anything that's going to help him stay away from drugs and alcohol would be a wonderful thing. If that helps him, that's good. But I'm not going to order it. All right, Mr. Riviezo, you feel like you can complete probation for us?
Yes, sir.
And you can blow in the machine properly once someone trains you how to use it?
I do.
All right. Mr. Riviezo, in clause 629957, the court accepts your plea of true with an explanation. I deny the state's motion to revoke your probation or to continue on probation with all prior requirements and a sanction of 10 days in the Bear County Jail, credit for time served, judgment satisfied, meaning as soon as we can get you out of there, we're going to get you out of there. Confirm he's on a Smart Start mobile device within 10 days. Substantial compliance, meaning he needs to register for any programs or classes and whatnot. He may not start them, but he needs to be registered for them within 10 days. So he's on the track.
And Judge, he has completed victim impact panel.
Wonderful.
And 11 hours of his community service.
Wonderful. He gets credit for anything he's done, any money's paid, that sort of thing. Mr. Riviezo, you can, I don't know what the fine originally was on this. If you want to do extra community service hours at the rate of $10 an hour for your fine and whatnot, you're welcome to do that if that helps you in some capacity. I'll let you talk about that with your lawyer.
Okay.
All right. Susan, what did I miss?
I think you got it all, Judge, and I'm sorry I misspoke. I was reading off the wrong document. He has not completed victim impact panel.
I was looking for that for a second.
Anyway, you'll have time to do that. All right. Do you have any questions, Mr. Riviezo?
I just need to run down, everything with my lawyer, just to not with.
Sure. Hey, Mr. Ross, do you have time to go in a breakout room, Mr. Riviezo, and explain all that to him?
Absolutely, Your Honor.
That'd be great. Pat, can you go ahead and send them out?
Yes, sir.
Good luck, Mr. Riviezo.
Thank you.
Okay, let's move.
Mr. Riviezo, one second, Pat.
Okay.
I'll be emailing some conditions to you. They'll be in your mailbox when you get out of jail. You need to electronically sign those and send those back immediately, okay?
Okay.
And do you have any questions about anything?
Not right now. I was just gonna ask him a couple of questions besides that.
Okay, all right.
We're gonna
And
put you in a
then,
breakout room with him.
yeah, and
Okay.
after today, just work with Mr. Fonseca and he will be sure to help you out in any way that he can, okay?
Thank you.
All right,
Okay,
good luck to you, sir.
Mr. Riviezo, can you see a button that says join? There should be 4 little buttons or little dots, and then you should hit that and it should show room, and you go back to the one that you were in. I believe it was number 2.
I don't see that.
Okay, then let me do it this way. I'm gonna move.
I see breakout rooms.
Yes, hit that.
And 2.
Go back to 2.
Go to, okay.
Okay, Mr. Ross, you can go back now.
Thank you.
Okay, Shannon Locke is stuck in a felony court for a while. I have to get back.
And we still have Mr. Rendell with Miss Aguilar.
Judge, if you can just give me about 5 minutes in a breakout room with Mr. Brindell, I think that we can get something worked out.
Let me let Mr. Brindell and the state know that I conferred, or I spoke to our staff attorney, and she says we can proceed on a contested, I may have told you this, contested motion to revoke probation with our supervisor instead of the original probation officer. Go ahead and go into your breakout room.
Okay, let me see where I can put you in. Okay. Ms. Galloway, you can go into 6 and I will put Mr. Brindell back in 6 with you. I don't know that he's there. Mr. Brindell? There you go. Well, he's there. I don't know whether he's there or not. I'm going to take us off of